Welcome again to the Melling Law YouTube channel, where we talk about different estate planning topics relevant to people living here in Utah. Today we're continuing this series about minor children inheriting assets. Specifically, how do they inherit different types of assets and what's the best way to plan for different types of assets. In our last video we talked about the tax deferred accounts. So these are IRAs, 403Bs, 401Ks, 401As, any kind of account where you're paying taxes only on what you have received in income from them, but otherwise they are being funded tax-free. This video specifically is about all of the other types of investment accounts. So any like a Roth IRA or a traditional brokerage account or stocks, bonds, mutual funds, anything like that. How should that pass on to the next generation, specifically to minor children? And these you have a little more flexibility because we're not bound by all these different rules that govern tax deferred accounts, because these are accounts that you've already paid the taxes, you've invested it, and you're either going to take it out tax-free like with a Roth IRA, or you're going to pay capital gains as you pull out. As these assets have increased in value, they have appreciated, and because that value appreciates, if you were to gift these assets during your lifetime, the recipient may have to pay a higher tax amount than if they had just inherited it. So the first rule with these is that you do want to make sure that that transfer is triggered upon death unless you have a good reason for not doing so. So that's the first rule here. But then the other is you do have quite a bit of flexibility as to how a minor child is going to inherit these. You could leave it directly to them, and then whoever their guardian and conservator is going to manage that. And because that's an unknown, that's probably not the best way to do it. Plus, they can do whatever they want with it once they turn 18. Another one that a lot of people will do is they'll leave it to another family member that's an adult, like that child's parents or grandparents or an aunt or uncle. The issue there, though, is we're not only exposing that asset to your own creditors and the child's creditors, but we're also exposing it to that manager's creditors at that point. So if they have something unexpected happen, whether it was a bad business deal or an accident, then that child's inheritance could be gone potentially. So that's another issue there, in addition to potential gift tax reporting and everything like that. So the best way to leave these types of investments to a minor child is through a trust. It gives you quite a bit of flexibility as far as who's going to manage the funds, how long they're going to manage the funds, under what conditions the child can cash out and obtain control over those funds. It gives you a whole lot more flexibility, and it's a lot safer. So if you have investments that you want to leave to a minor, you're definitely going to want to at least consider a trust and get some professional help. If you need any help from us, feel free to reach us at 435-572-0807 or at mellinglaw.com.